Hello, I'm Luis O'Naughton, a partner at Hughes Hubbard & Reed, and the immediate past president of the Miami International Arbitration Society. MIAS promotes international arbitration and mediation, as well as parties selecting Miami and Florida as venues for international arbitrations. Critical to MIAS's mission are its efforts to promote best practices in international arbitration, as well as to provide a forum for the international arbitration community to exchange ideas and information on important issues affecting international arbitration. For example, I'd like to right now highlight the efforts of John Barquette of Shook Hardy, who on behalf of MIAS has made a submission to the UNCITRAL Working Group 2 session on the explanatory notes to the expedited rules. John has made an incredible submissions throughout the years on this, and we thank him. For example, today's mock argument, we have registrants from almost 30 countries. MIAS is excited about today's event. In November, the Florida Supreme Court will hear argument in the case of Airbnb versus John and Jane Doe. The case presents a foundational issue of whether an arbitration clause's adoption of arbitration rules that expressly grant the arbitrator authority to decide on his or her own jurisdiction constitutes clear and unmistakable evidence that the parties intended to empower the arbitrator to rule on the issue of arbitrability. It's an important issue that may well end up before the U.S. Supreme Court. Given its importance, MIAS submitted an amicus brief on the issue, which you can see by simply going to our website, mias.org. As I mentioned, today we are going to have a mock argument of the Airbnb case. Let me start by introducing the bench. Sitting as Chief Justice for today, we are proud and excited to have Professor George Berman of Columbia Law School. I might add an excellent law school having nothing to do with the fact that I graduated there. I'm not going to list Professor Berman's lengthy biography here, but suffice it to say that he was the chief reporter on the restatement of the U.S. law on international commercial and investor state arbitration. He is also the director of the Center for International Commercial and Investment Arbitration at Columbia. Perhaps most relevant today, Professor Berman submitted his own amicus in the Airbnb case. However, don't worry about his putting a thumb on the scale of today's arguments, since his co-justices today on today's panel are the authors of MIAS's own amicus submission. The first associate justice I want to mention is Harut Samra, who leads DLA Piper's arbitration practice here in Miami. Second is Ed Mullins, a partner at Reed Smith who heads up MIAS's amicus committee. He's the former chair of the Florida Bar Board Certification Committee for the International Litigation and Arbitration, and former chair of the Florida Bar International Law Section. Indeed, the associate justices are all certified in international litigation and arbitration by the Florida Bar. And let me use this as another plug to those of you who are interested. You should try and become certified with the Florida Bar. Third is Carlos Concepcion, the chair of Shook Hardy and Bacon's international arbitration practice. Finally, last but not least, is William Hill, a partner at Gunster practicing international litigation and arbitration. As I just mentioned, Harut, Ed, Carlos, and William led the team drafting MIAS's amicus brief. However, they could not have done so without the help of the two lawyers who today will argue the case. On behalf of petitioner Airbnb is Stephen Suker, who works with William Hill at Gunster. On behalf of respondents is Anabel Blanco, a member of the international arbitration team at Reed Smith. Finally, the moderator for today is Giovanni Engels, a member of the international arbitration team at Shook Hardy. Gio will provide us a brief description of the case and will later moderate the discussion after oral argument. If you have questions that you would like to present to either the justices or the advocates, please submit them using the Q&A button to the right of your screen. We'll deal with those at the end of the session. Finally, I note that this event is being recorded, and the recording will be posted to the MIAS website, as are all MIAS events. I encourage everyone to visit the MIAS website, as it's a great site for international arbitration resources, recent arbitration news, and profiles of international arbitrators. If you are not a member of MIAS, please join. Anyway, let's now begin with the main event, and I pass the baton over to Gio. Gio?
Thank you, Louis. Let's talk about how this dispute ended up on the Florida Supreme Court's docket. An anonymous Texas couple, John and Jane Doe, filed a complaint against Airbnb and a condo owner who listed his property on that platform. The complaint includes claims of intrusion and constructive intrusion. Plaintiffs rented the condo unit for a 3-day vacation and later learned that the owner installed hidden cameras and recorded their private activities without their knowledge. Plaintiffs filed their complaint in Manatee County Circuit Court. In response, Airbnb moved to compel arbitration. It noted that plaintiffs were subject to arbitration under Airbnb's terms of service. Plaintiffs agreed to be bound to arbitration by accepting a click-wrap agreement when they created their Airbnb accounts. The click-wrap agreement includes a dispute resolution clause, which provides that the parties must settle all disputes by binding AAA arbitration under their commercial arbitration rules. Airbnb argued that the circuit court should not even consider whether the Doe's claims were arbitrable, because Rule 7 of the AAA rule states, the arbitrator shall have the power to rule on his or her own jurisdiction, including any objections with respect to the existence, scope, or validity of the arbitration agreement, or the arbitrability of any claim or counterclaim. The circuit court granted Airbnb's motion to compel arbitration because, quote, it was powerless to determine arbitrability. The parties signed an agreement which incorporated the AAA rules, and thus the issue of arbitrability must be decided by the arbitrator. On appeal to the Second District Court of Appeal, the DCA reversed the circuit court. It held that a reference in the arbitration rules that grants arbitrability to an arbitrator does not clearly and unmistakably supplant the court's power to decide arbitrability. The court observed the following 3 points. First, the click-wrap agreement itself is silent on the issue as to who should decide arbitrability. Second, its reference to the AAA rules was broad, nonspecific, and cursory. Third, even if one looks to Rule 7, the power granted to the arbitrator to decide arbitrability is not an exclusive power. While admitting that its holding was an outlier in the jurisprudence of arbitration, the Second DCA still concluded that the click-wrap agreement's arbitration provision and the AAA rule it references are ambiguous as to the intent to have an arbitrator decide arbitrability. The court reversed and remanded with instructions while certifying the conflict for Supreme Court review. Now, this is the part where I start the proceedings, I put on my marshal hat, and I started with the traditional oyez opening. But given that we're a Miami-based organization, I hereby declare, oye, oye, oye. The Florida Supreme Court is now in session for case number SC20-1167, Airbnb versus Doe. Justices of the court, Chief Justice Berman, you have the floor.
Good day, counsel. We look forward to the argument we're going to hear today on this important issue. I'd like to remind counsel that each side is allotted 20 minutes, from which you may reserve some moments for rebuttal. Before we begin, may I ask counsel for petitioner whether you intend to engage in rebuttal?
Yes, Your Honor. I'd like to reserve 5 minutes for rebuttal.
Thank you. And Ms. Blanco?
No, Your Honor, we will not be reserving any time for rebuttal.
Okay. Thank you. Thank you very much. I think our time is short. We should get started. And so the court invites Mr. Sugar to present his case. for petitioner.
May it please the court. Whenever a contract has an arbitration clause, the very first question to be resolved in a dispute that arises is who decides whether the claim is arbitrable or falls under the arbitration clause at all. And we're here today because the Second District's decision below is an outlier in every way in its approach to answering that question, both within Florida and in federal courts, which have over and over reviewed this issue of substantive federal law. In fact, for more than 25 years, every federal appellate court that has looked at this issue has gone the other way from the Second District and decided that incorporation of institutional rules, which language giving the arbitrator authority to decide arbitrability, is sufficient to delegate that question to the arbitrator and to satisfy the binding, clear and unmistakable delegation standard set by the 1995 First Options U.S. Supreme Court case. At least two.
Let me jump in here and ask you to comment briefly on the relevance, if at all, according to your perspective, on whether the issue should turn on the sophistication of the contracting parties. As you know, the Does have claimed that they are unsophisticated, and putting aside the issue of whether that topic is preserved for appeal or not, what is your view on whether that is a relevant topic that the court should consider? And how is it that the court should apply the first option standard if it deems that issue or that topic of sophistication to be relevant?
Yes, Your Honor. Respondents do argue with absolutely no evidence presented on that point in the record. They were too unsophisticated to be bound by the agreement. However, this entire issue is a red herring. The standard at issue today will be applied everywhere, not only to contracts of adhesion, but to traditional arm's-length negotiated contracts. And in any event, this court has held that a party is bound by an unambiguous term in a written contract, even if he or she hasn't read it. And for example, the Allied Van Lines v. Bratton case from 1977. And so the petitioner's position is that the issue is entirely irrelevant, and it really is not clear how that would be incorporated, a finding of sophistication or lack thereof of the parties, into the binding U.S. Supreme Court standard. Clear and unambiguous delegation.
Counsel, as I understand it, nowhere in this agreement did the parties expressly state that arbitrability goes to the arbitrator. And your argument's based on this incorporation of the rules. I mean, how hard is it to put that in there? It's one sentence. I mean, can't we take out of that the fact that they put that sentence in, that there's really no indication that they expressly delegated to the arbitrator this important issue?
Well, on the parties agree to arbitration clauses so that there's no debate as to whether the arbitrator or a court will review. There's no question that parties' ability to incorporate material by reference is appropriate. This is beyond accepted practice. The real issue here is the language of the incorporated rules, stating the arbitrator shall have the power to rule on his or her own jurisdiction. Logically, it's either one or the other, the court or the arbitrator. And the rules state it's the arbitrator that has the power to rule.
But the rules don't say that the arbitrator has the exclusive jurisdiction. It simply gives the power of the arbitrator to rule on his own jurisdiction. Isn't that right?
Power to rule is the power to rule. The word exclusive is not illogical or necessary to include. In addition, the word exclusive does not appear at all in First Options, or in Henry Schein, the 2019 U.S. Supreme Court case, or in Terminix from the 11th Circuit, or in Reunion from the 5th District of this state, or in Glasswell from the 3rd District of this state. Respondent's nonsensical position appears to be AAA rules give concurrent authority to both the court and the arbitrator to decide arbitrability. This would lead to the absurd situation of a race. Have each party's preferred forum be the first to rule on this issue, which is not the expeditiousness that was agreed.
But the arbitrator, oh, sorry, go ahead. You can answer your question.
Right. Wouldn't that be the case in the absence of a delegation provision? Isn't it the case in the absence of a delegation provision that a party can bring jurisdictional challenges either to a court or to a tribunal?
Well, it's petitioner's position that...
Where is the race that you are suggesting is created by the delegation? Doesn't it pre-exist a delegation?
Well, in 2019, the U.S. Supreme Court unanimously held that when a contract delegates the question of arbitrability to the arbitrator, a court possesses no power to decide.
Mr. Sukkot,
Um,
you haven't answered my question. I understand what the court held, but you seem to be arguing that there will be a race to a forum if this delegation is not respected. And I'm asking you, isn't there a race, if you will, in the absence of a delegation? Don't parties have a right to challenge the arbitrability of a dispute either before a court or a tribunal? How is the presence of a delegation exacerbating that? Is my question clear?
Because the parties agreed relying on the overwhelming majority rule in federal courts and
Mr.
lower
Sucre, you
courts.
persist in not answering my question. I'm asking you about your alleged race to a forum, and you're suggesting that that is triggered in the presence of a delegation.
It's
Now, I'm
triggered in
asking
the
you,
presence
yes
of
or
the second
no.
district outlier
Mr.
opinion interpretation of that
Mr.
delegation.
Sucre, I haven't
Let me see if I can ask a different question that maybe help you out. I mean, it seems, I guess the question is, the preference of the Chief Justice's question is that there is no race. But is that really what the rules are intended? When I'm looking at the dissent of Volante in this case, where he talks about the power to decide is the power to decide. Do you believe that the rules intended for this dual race that the Chief Justice is talking about, that both sides? Do you believe that, or do you think there's another operation going on?
Exactly. The rules did not intend that, and that would be a impractical and really undermine the entire advantages of having a dispute be decided in arbitration, which are not to get clogged down in the courts at the outside of a case, but to proceed expeditiously. And that carve out of the arbitrability issue would completely obviate the efficiency that the parties intended to agree to, and that the rules intended to provide to the parties. And incorporating those rules has been understood to accomplish that result. What's really at stake today are the clear expectations of contracting parties who have chosen to do business in Florida. As many as amicus.
I think what perhaps what you're trying to tell us is that whether there is a race now or there isn't, the fact is that a delegation provision that is respected would eliminate any concerns of a race. Isn't that, in effect, what you're trying to tell us?
That's exactly right, Your Honor.
Well, Mr. Sucre, let me ask you a question about a different race and ask you whether this is something that this court, as the Florida Supreme Court, should be concerned with. At the moment, we're faced with, from your brief, I understand your position to be overwhelming authority from the federal courts, including, I believe, the 11th Circuit, which would encompass the state of Florida, which holds in general that a general incorporation of arbitration rules that then have the delegation of competence to the arbitral tribunal. That's the rule in the federal courts, the 11th Circuit, and the vast majority of the circuits that have ruled. That's your position?
That's correct.
Okay.
This is an issue
But let me ask this. Should we be concerned if we rule in favor of the respondents here and uphold the holding of the second DCA below? Are we going to have a different rule for arbitrations in the state of Florida, depending on whether the parties attempt to go to federal or state court to challenge arbitrability? And if so, should that be a concern?
It should absolutely be a concern. Affirming the second district's outlier opinion would affect thousands of companies and national and international companies doing business in this state and make it much more difficult including companies like Walmart, CVS Health, and Home Depot, to name only a tiny few that have relied on contracts like these. And exactly as you're mentioning, the disparity between federal courts in this state and state court and the state courts under an affirmance would be extremely confusing and would not make this state an attractive place to do business or to center their the arbitrations of companies.
Mr. Stuckert, I am certainly understanding the reliance argument that you are advancing, but in the exchange thus far, I've heard very little about clear and unmistakable. That has barely surfaced in your advocacy. Now, I would like to ask you, if you were intent on making this delegation clear and unmistakable, where would we find it and how would it be worded? I'm asking you, in fact, personally. I'm asking you, Mr. Stuckert, if you were intent on this delegation provision being clear and unmistakable, how would you word it? Where would you put it?
Yes, Your Honor. In incorporating the AAA rules into the agreement by reference, the parties here incorporated the full plethora of provisions contained within the AAA rules, including, but in no way limited to, the provision of who decides arbitrability. It would be unnecessary for the parties in 2018 to have extracted the arbitrability rule, the Rule 7A and B, of the vast AAA rules and put it in the body of the agreement because they agreed to it all. And what you're describing is a belt and suspenders approach that some corporations may have recently taken, but Airbnb should not be penalized for not having reiterated in its agreement what is already clear and unmistakable.
Mr. Stuckert, I'm not understanding exactly what you're saying. Am I understanding you to say that if you wanted to be, let us say, as clear and unmistakable as possible, so let me alter my question slightly. If you wanted to be as clear and unmistakable as possible, where would this provision be found and how would it be worded?
They're both equally clear and unmistakable under the first option standard, which elevated the question, it elevated the standard relative to a general presumption of resolving any doubts in favor of arbitration. But the standard was not as clear and unmistakable as possible, where there's a spectrum.
Counsel, isn't it clear and unmistakable?
Continually make it more visible within the contract.
Counsel, isn't it clear and unmistakable, but the rules were incorporated? Isn't the whole issue what these rules mean? Isn't that what's clear and unmistakable here? There's no question, but the delegation is clear and unmistakable. Isn't that right?
Absolutely, Your Honor.
Mr. Stuckert, let me ask you this. Should the court focus on what the contract says or what it could have said?
Again, that's an excellent point. The court should focus on what the contract actually says, and incorporation itself is not is an accepted method, and that part of the second district's holding was an extreme outlier. The language of the rules themselves are themselves clear and unmistakable.
Okay, Mr. Stuckert, you keep talking about an outlier, and I know you've cited a lot of federal cases. Those cases are not binding on the Florida Supreme Court, but also we've had, since the opinion from the second DCA, the fourth DCA has actually joined. Isn't that correct in the Falang case? How does that affect your argument?
Yes, the fourth district dealt with this issue twice so far in 2021. First in the Falang case, which was in March of this year, but then subsequently in the Laurel Point decision in June of this year, they explicitly distinguished the Falang case and came down much closer to the side of the petitioner here. And to the third DCA and fifth DCA, where the agreement at issue was much more similar.
Counsel, you've used 4 minutes of your rebuttal, and so I know that some of us, including yours truly, have repeated on your rebuttal. So we'll go ahead and give you 3 minutes on rebuttal and turn it over to your opponent. Thank you so much.
Just a quick point of order. Council still has his full 5 minutes of rebuttal remaining.
I see. I misunderstood
15
the message.
minutes just ran out, yes.
Fair enough. You have 1 minute then to wrap up your opening. Council, you have 1 minute to wrap up your opening.
Oh, I have an additional minute. Okay.
Yeah.
Mr. Super,
yeah,
in that minute, tell us why the contracted issue meets the first standards options. Focus on that and tell us why it applies or meets the first option standard.
Yeah, so the power to rule has been understood to be to grant that authority to the arbitrator, and the word court does not appear in the rule. The word exclusive is not part of the first option standard, and then the reason that the overwhelming majority of courts, both every federal circuit court to have looked at the issue, and at least 2, maybe 3 districts of this state, of the 5 districts of this state, to have concluded that this is because it's correct. Sometimes the uniformity of opinion is an indication of correctness.
Okay. Thank you, Mr. Sukert. And you have reserved 5 minutes for rebuttal. May we hear from counsel for respondent?
May it please the court, my name is Annabelle Blanco, and I will be presenting oral argument today on behalf of respondents, John and Jane Doe. Honorable members of the court, the issue before you today is this: whether incorporation by reference of rules of arbitral procedure, like the AAA rules at issue in this case, in arbitration agreements constitutes, and I quote, clear and unmistakable evidence that parties intended to delegate determinations of arbitrability to arbitrators within the meaning of First Options of Chicago versus Kaplan. I'm going to reiterate the standard because that is determinative of this case.
Blanco, I think we understand what the standard is, and what troubles me a bit about the position that you've taken is the issue of sophistication. It occurs to me, or perhaps I think it is that way, that a contract is either clear and unmistakable or it isn't. And are you suggesting that we have 2 different standards of clarity and unmistakability, one that applies to parties that are sophisticated and one that applies to parties that are not sophisticated? How do we do that if we were to attempt to do that?
Yes, Your Honor. The issue of sophistication is relevant because the clear and unmistakable standard has to be interpreted as a standard of intent, and the party's sophistication is relevant to their intent. A sophisticated party is much more likely to have intended to have delegated the issue of arbitrability under, for instance, perhaps the facts of this case, although that's also disputable, than an unsophisticated party which is not aware, perhaps, that even arbitration exists or is an alternative method of dispute resolution. So when reading an agreement, like the terms of service in this case, would not even have known to look not only at the terms of service for the possibility that their right to go to court on this issue would have been eliminated, but also to, in fact, go through the separate, non-attached, but linked AAA rules to see whether those rules, in fact, delegated an issue to an arbitrator.
What about a hypothetical scenario where one of the contracting parties cannot read at all? And what do we do in a context like that where hypothetically everybody would agree that the contract is clear and unambiguous and unmistakable, but yet the party cannot read? What do we do with a fact pattern like that?
Well, Your Honor, in that case, there's 2 points. First of all, we shouldn't avoid making the clear and unmistakable standard as amenable as possible to as many people as possible, just because we run the potential of not making it acceptable to everyone. So the fact that a small portion of people might not be able to read the agreement does not eliminate the fact that sophistication is still important, that the standard will be different to different types of people and different types of people that are entering into the contract or entities. But on the second point, well, it's about not whether they can read at all. Maybe this is a little more literal than you intended. It's about what is understood, what a person in this case that is reading or getting this language is going to have understood. And the issue here is that this language, the language of the AAA rules, is not language of delegation. It is not language.
Let's talk about that, counsel. Let me just see if we're on the same page. It is clear and unmistakable that the parties agreed to the AAA rules, correct?
Yes, it's clear and unmistakable that they were referenced.
Counsel, let me see if I'm on the same page. And you also have no problem, correct, that you can incorporate by reference, correct? So if the parties say we're going to apply the AAA rules, it's clear and unmistakable you can't apply the ICC rules or the JAMS rules. Is that fair?
Yes, Your Honor.
Okay, so then isn't the real question is what these rules mean? And I read the dissent that we're on review, and his point is, do you read these rules as suggesting that a court's going to be involved in the arbitrability decision? Where in the AAA rules is there any suggestion that a court's going to be involved in the determination of arbitrability? Please help me.
Your Honor, the plain language of the rule, all it does is confer on the arbitration tribunal the power to make the arbitrability determination. The rule says the arbitrator shall have the power. The meaning of that is that the arbitrator will have the power. It doesn't mean that the court will not also have the power. And under a real delegation, you have to take that power away from the courts and give it to the tribunal. Now, what this language
competence that we're not, the whole point of in international arbitration of competence, isn't it? That we're going to have the arbitrators judge their own jurisdiction and not get courts involved in that. And they're going to have, because what I'm hearing from Chief Justice is this game where parties agreed to arbitration and now we're guaranteed 2 proceedings. How is that possibly efficient? Please help me.
Respectfully, Your Honor, that's not the purpose of the competence clause like the AAA rules in this case. The purpose of the clause is that where an arbitration is taking place, the tribunal, so that the parties don't have to stop mid-arbitration, the tribunal will be able to make a determination as to its own arbitrability, absent a real delegation, subject to a court's review of that determination. And this actually serves, this interpretation of the language of the rule serves the 2 main purposes of international arbitration. The first being time and efficiency, as Your Honor just pointed out, because mid-arbitration, the parties will not be forced to pause and stop and go to the courts in the middle of the arbitration, but also this interpretation serves the purpose of legitimacy. Arbitration is a creature.
But that only works if they file the arbitration first. Right? That's all convenient when they file the arbitration first. Now you're talking about what we're going to do with the award. But we're talking about the case we're on right now. That didn't happen. You have a plaintiff who filed a lawsuit, right? And then in violation of the arbitration agreement, didn't go to arbitration, ask the arbitrator whether or not they should be there, going to court first. That's what we're here. How is that efficient?
Well, that's exactly the purpose of the first option standard, Your Honor, where parties did not think about the issue of who will determine arbitrability. The standard creates a default rule that the courts will determine this issue. Because the arbitrability determination is so important to the legitimacy of the arbitration, and the parties have to have explicitly consented to it. In this case, the fact that the parties filed in court first is evidence of the fact that they would not even have considered this at all. The Does in this case were unsophisticated parties, likely have never been involved in arbitration. Yes, Your Honor.
Blanco, I'd like to ask this. I'm not sure where I read it. Maybe it was in one of the amicus briefs. But I read that there is a concern that if we do not allow courts the ability to review the arbitrability at the outset of an arbitration, there will be no realistic opportunity to review it at the end of the arbitration. Do you agree that that is a concern if we reverse the second DCA? And if so, should that be a concern that this court should take into consideration?
Yes, Your Honor, absolutely. Under U.S. law,
Could you,
the
could
U.S.
you
law.
explain that? Go ahead. Yeah, go ahead.
Yes, absolutely, Your Honor. Under U.S. law, a real delegation of arbitrability means that a court will have that a court's review of an arbitrator or arbitration panel decision as to arbitrability has to be highly deferential. It must be, there's very little review in that regard, which means.
Counsel, you agree with me that had this clause simply said that the issue of arbitrability goes to arbitrator, you would have no case. That one sentence was in this clause, correct?
Well, not necessarily, Your Honor. We've been focusing on the language of the clause.
Well, I'm saying, but if it actually said arbitrability is decided by the arbitrator exclusively, you would have no argument, correct?
If the parties' agreement, the actual terms of service, had included that language, we would be more satisfied that the clear and unmistakable standard has been met. But that still does not address.
Going back to Chief Justice, what would you write to make sure that you are satisfied? You'd be more satisfied. What would completely satisfy you?
Well, my point with that question, Your Honor, is that even then, that language does not, just incorporating the language does not take into fully consideration the level of sophistication of the parties. But yes, it would be much more likely to meet the clear and unmistakable standard.
You really don't think we ever would be able to delegate arbitrability to arbitrator because your clients are not sophisticated enough. Isn't that your argument, counsel?
No, not necessarily, Your Honor. It would be fact specific. Perhaps in order to expedite the process, we would be able to create groups of sophistication. In that case, perhaps maybe include, instead of, we remind the court that this was a language that was included that was 2 steps removed from what the Does actually read. There was the click-wrap agreement in which were linked the terms of service, in which was linked the arbitration rules. So in the case of consumer contracts, perhaps with something as big as taking away your power to have this issue before a court, the language should be in the click-wrap agreement itself, the actual thing that most consumers read.
This contract was between Google and Apple, and just like all the other contracts we've seen in these federal cases, they simply incorporated the rules. Would we get a different result here?
Well, yes, Your Honor. Google and Apple have their teams of lawyers that are hired to do these things and think of these issues compared to the Does that maybe don't even really know what an arbitration is, besides knowing what the definition of the word is, but not that.
The ruling you want from us is that corporations. Go ahead, Your Honor.
Mr. Blanco, do I understand then that? Well, let me ask you. I thought you were taking the same position you would take even if the Does were sophisticated. I want to be sure I understand. I want to understand the weight that you're attributing to their alleged unsophistication. If they had been sophisticated, fully sophisticated, would that change your argumentation? Or are you maintaining that even as between sophisticated parties, the way this provision was worded and or where it was found would be insufficient?
Ms. Blanco, the correct answer is yes.
Yes.
Okay.
As our position is that even
the Chief Justice is giving you a softball question. The answer is yes to that question.
Yes.
Now I have.
I'm not so sure. I was buying this. These people are not sophisticated enough to know how to incorporate. Apparently,
I have less than a softball question for you, or I should say more than a softball question for you. When I read your opponent's brief, a great deal of emphasis, and frankly, in my judgment, one of the more meaningful arguments is the reliance argument, that for a substantial period of time, the counsel have been led to believe that what was found in the rules in this case, incorporated by reference, was clear and unmistakable enough. Now that argument figures very heavily, and it figured heavily in Mr. Suckert's advocacy. So I am genuinely interested in knowing how you see that reliance interest. Is there a reliance interest? How substantial is that interest? Is it great enough to warrant an abandonment of your position?
Yes, Your Honor. Well, I have three points in response to that question, those questions. The first one is that just as opposing counsel cites examples of companies that have, like Airbnb, that have included language incorporated language of the AAA rules in this manner, there are just as many or even more examples of companies that have taken the very small additional step of including clear and in the agreement itself, the language, the arbitrator is the only one has the exclusive authority to make this determination. So we don't agree that it is so uniform, that this precedent has been so uniformly relied on. As a second point, it's actually unclear what the parties that have relied on this precedent, if they have, are relying on, because not every decision that has interpreted rules has interpreted the same set of rules. In fact, Your Honor, the first such decision that seems to have interpreted a set of rules like this one is Apollo versus Berg. It's a First Circuit decision from 1989. It actually predates first option, so could not possibly have applied the correct standard for clear and unmistakable evidence. But even more importantly, to Your Honor's question, the rule language that the Apollo decision interpreted was language from ICC rule Article 8.3, where the language of delegation, what it actually said was any decision as to the arbitrator's jurisdiction will be taken by the arbitrator himself. So
Ms. Blanco,
to make my point clear, yes, Your Honor.
I know we can go back to the 1989 case, but since then, you would agree that there have been a considerable number of federal court cases that have gone against your position. You would acknowledge that, would you not?
I would acknowledge that, but Your Honor, I would acknowledge that generally it seems like these courts are relying on one another to make the point that incorporation by reference of arbitral rules is enough to delegate the issue of arbitrability.
And clearly you would agree that that has been the general rule, but the question really was a separate analysis required every time, or are courts simply trying to rely on a general rule that a general incorporation of rules that have a delegation of competence to the arbitral tribunal sufficient, so that we don't have a case-by-case issue, so that we're not bouncing back and forth between arbitral tribunals and courts every time we're in an arbitration, but we simply know that the rule is the rule and a general incorporation is sufficient. Wouldn't that be better for the efficiency overall?
About 3 minutes,
well,
counsel.
Thank you. Well, Your Honor, that's precisely the point. These decisions, they don't provide any analysis. They don't even distinguish between the language of the rules themselves. So
hasn't it become a term of art, though? I mean, why if you have every circuit has said the same thing, hasn't it just become a term of art when you use incorporation by rules? That's become a term of art that you're incorporating all the rules, including the authority of the arbitrator to determine his arbitrability, and that's been interpreted under the law to also include the exclusive ability to do so, and that's a term of art. Why hasn't this not become a term of art through federal law? By the way, this is federal law, right?
Yes, Your Honor. Well, on that point, it's the fact that it's federal law just means that it's not binding on this court. It's at most advisory, because our position is that these decisions aren't persuasive enough because of the lack of analysis. But on the term of our point, Your Honor, if that was the case, if parties were really paying such close attention, especially large corporations with sets of counsel, if they were paying such close attention to this issue, wouldn't it have just been easier for them to incorporate the language that they should have incorporated in the first place? If this term of art was so persuasive, it would have just been easier if they were really paying attention to what was going on at this level. it would have just been easier for them to address the issue by making a small change in the language of their agreements. Excuse me. And on
over the course of the last several minutes that intrigued me, and I would like you to expand on it as we get to the end of your argument. You raised the question of the legitimacy of arbitration, and I know one of the amici have addressed that. Could you expand on that just for a few minutes so we can understand a little bit better what you mean by legitimacy as something that could be in some way challenged if we don't ultimately side with your client?
Your Honor, yes. The point is that arbitration is a creature of contract, and the arbitrability determination is fundamentally different than other determinations that are made with respect that would be made by the arbitrator or the arbitration panel. Because the arbitrability determination goes to the beginning, to whether the parties have actually subjected themselves to arbitration. It encompasses such issues as whether, for instance, a non-signatory, which was the case in First Options itself, a party that has not signed the agreement could be subject to to arbitration, or whether, for instance, a specific claim falls under the arbitration. To say that parties will be subjected to arbitration, to this determination by an arbitration panel, and this decision be taken away from a court, which is a fundamental right, without clear and unmistakable, without absolutely being sure that the parties gave up that right to be subject to the court, undermines the legitimacy of arbitration and actually hurts arbitration more than any time or efficacy considerations that could possibly be won by just assuming that this language is enough, that language under the circumstances of this case is enough. If I could just have one moment to...
Yes, please.
I think my time is up.
You may wrap up.
Thank you, Your Honor. Just as a final point, in conclusion, and as aptly summarized by the Second District opinion that gives rise to this appeal, in the case at bar, what's going on is that we have an arguably permissive and clearly non-exclusive conferral of an adjudicative power to an arbitrator that's found within rules not attached to the agreement, that the agreement itself did nothing more than identify the applicability of that body of rules if the arbitration is convened, and this is not clear and unmistakable evidence that the parties agreed to delegate the issue of who decides from the court to the arbitrator, and it cannot be what the Supreme Court meant when it set forth the clear and unmistakable evidence standard.
Thank you, Ms. Blanco. So, Mr. Sukkert, you have 5 minutes at your disposal.
Thank you, Your Honor. As to the sophistication of the parties, First Option's clear and unmistakable delegation is not a subjective standard. It doesn't take into account the understanding of the parties.
Has the Supreme Court ever has ever come up with different rules for sophistication of the parties in terms of how they interpret the
Federal 11th Circuit addressed that in a decision from this year in the checking account overdraft multi-district litigation. We have never distinguished agreements involving sophisticated and unsophisticated parties, at least within that circuit. In fact, our precedent includes cases about agreements involving unsophisticated parties. And Respondents' Counsel also...
Mr. Sukkert, let me ask you to comment on your views regarding whether the concept of clarity and unmistakability is a floor or is it a ceiling? Does it shift? Is it either clear and unmistakable, or is there a concept where it can be more clear and more unmistakable? Is it a sliding scale? Is it a floor? Is it a ceiling? How flexible is that concept?
Well, as far as meeting the standard, it's more of a floor. It's more of just a binary. Do you meet the standard or do you not meet the standard? And additional efforts to make things even clearer and stand out more relative to the other provisions in the agreement or that were incorporated as part of the rules are beyond the standard and don't and are unnecessary.
Going back to Chief Justice Berman's comment on how would you write it? I suppose that one could make it more clear and more unmistakable, but by saying, and for example, inserting the word exclusive. But does that necessarily mean that in the absence of the word exclusive, it is not otherwise clear and unmistakable already?
It is. You're already clear and unmistakable. I mean, parties now going forward, given this case, are already adding the word exclusive and putting a statement in the body of the agreement. But in 2018, Airbnb and many other companies should not be invalidated in their understanding of the law at that point. The 11th Circuit clarified in that same opinion earlier this year. We have repeatedly ruled that reference or incorporation of AAA rules with language providing that the arbitrator shall have the power to rule in his or her own jurisdiction demonstrates a clear and unmistakable intent, and that clarifies decisions from that circuit going back to 2005.
Oh, go ahead. Go ahead, Mr.
No, go ahead,
A little bit of a problem with a portion of the answer that you just gave. The principle of competence has been with us for an extremely long time. It's not a new concept, even if it is incorporated into the rules. Now, I'd like to remind you that FAA Section 4 says that a court is to compel arbitration unless the validity of the arbitration agreement is in question. That is what FAA Section 4 says. It plainly invites a court to examine the validity of an arbitration agreement. And competence was in effect back then. So I'm having a really serious problem understanding how you can take a competence clause and override FAA Section 4 when there never was a contradiction between competence and FAA Section 4. These rules did not invent competence. I think you know that. They didn't invent it. That pre-existed, and it pre-existed for decades. Now, it seems to me that if you're going to rewrite competence and give it a negative as well as a positive dimension, what are you doing to FAA Section 4? Do you realize that you're writing FAA Section 4 out of the FAA?
I only have 1 minute left, so I'll address that. Judge Berman already acknowledged there was reliance by an enormous number of parties in federal courts.
That's a different matter, Mr. Stuckert. I know
Counsel, isn't the answer to the Chief Justice's question? He talks about validity, but are we really talking about validity here? We're not talking about whether or not there was an arbitration agreement. We're not talking about whether or not it's unconscionable. We're not talking about that. We're talking about whether or not the claims sued upon are actually arbitrable. What's that got to do with validity, Counsel?
That's exactly right. And these are rules accepted by international parties, the AAA rules, to make it easier for them to do business with U.S. entities. The Second District's decision is raising questions about that under federal U.S. law. That's definitely an outlier position. This court should reject attempts to steer it down a path based on jurisdictions outside this country, but should respect the expectations of the parties in agreeing to resolve their disputes expeditiously.
You know, the word validity doesn't appear in there. It is whether it is in question, whether the making is in question. So, Mr. Mullins, my dear colleague, I may have used the word validity, but if you go back to FAA Section 2, it talks about whether the making of the arbitration agreement is called into question. I believe
we're not there either, are we?
Of course we are.
No, because we're not. The only question we're determining here is who's going to decide whether or not the claim sued upon are subject to arbitration. We're not questioning whether or not there's an arbitration agreement. We're not questioning whether or not it's an unconscionable agreement. We're not questioning any of that stuff.
We're questioning the making of the arbitration agreement. The making of the arbitration agreement. It's questioning consent.
Well, unfortunately, the Supreme Court's never ruled that way. Is that or am I wrong on that?
It's a plain reading.
Exactly correct. Those other issues aren't before the court today, and they don't arise in this particular case. And so I believe I'm out of time. I don't know if
you are. You're out of time. So thank you to both of you, and we're going to turn this over back to Mr. Engels now.
Well, I would like to close the session. May I?
Yes, please.
Absolutely.
Okay. I declare this this audience closed. Thank you, counsel, for your energy, your clarity, and your unmistakability.
Thank you very much. I'm inclined to just not ask any follow-up questions at all and just have Professor Berman and Mr. Mullins just continue their conversation in an effort perhaps to recreate the discussions that were happening while the restatement was being, while the language of the restatement was being discussed. Professor, what can you tell us about that process, your involvement there, and I guess the evolution of the debate and how that ended up in its final form?
Sure, be glad to do so. It was hotly contested within the council, within the advisory committee, not in the plenary session. I'm not quite sure why, but it was hotly debated at those two levels. Frankly, the argument seemed to come down to this, or the two arguments seemed to come down to this. Those espousing Mr. Suckert's view were basically of the opinion that this would impair arbitration so considerably that we should be prepared to treat Rule 7 or its equivalent as clear and unmistakable. The view that prevailed was that the principle of consent is so fundamental, and the court in first options made that so clear by establishing a clear and unmistakable evidence standard, that more should be required to meet that standard than a garden variety, practically boilerplate concept of competence, which, as I mentioned in my amicus, is ubiquitous. There is hardly an arbitral proceeding today in which we don't have a competence clause, either in the agreement or in the arbitration law, as in the UNCITRAL model law, or in the rules. So if a mere incorporation of the competence principle meets the standard that the court set out in first options, then the presumption that Justice Breyer established in first options disappears. Now, that is the view. I know I elaborated my view more at greater length than I did the opposing view, but that is why the restatement ended up where it did, in full knowledge that the federal courts were not in agreement. And to put a fine point on it, Giovanni, we are told in the restatement that it is with the greatest degree of reluctance that we should disagree with the federal courts, especially when they've spoken unanimously. And it is only in circumstances where we think a fundamental injustice or mistake has been made. And the committee and the council were of the view that this was one of those cases, and we should not go along with the crowd. And I don't think this court should go along with the crowd. As Ms. Blanco mentioned, there isn't a single decision to the opposite effect that contains a single reason. What they say is conclusory. If the arbitrators have power, the courts cannot. That's the extent of the reasoning.
So I was one of the guys that debated this with the reporters at the restatement. And what happened was, this is one of the issues the restatement, and I came in halfway in on it. I joined the ALI, and I think the professor could correct me, but I think that it was like a 10-year, or at least a 10-year program. It takes a long time. And so the process is, in case everybody wants to know, and you'll correct me if I'm wrong, So you have the council that has to approve it, but there's these members consultant that we look at and work on it, and then the advisors, and then there's the actual reporters, and each reporter has a chapter to work on. And it takes a long time, and there's significant, a lot of work, and the reporters do the bulk of that work, and then they bring it to the advisors, and what do you think about this? And we say, well, we think this is wrong, or you think about this case, whatever, and then they got to go back. And then this takes about a year and a half or so, and then it goes to the council, and then the council votes it. I think the answer to the professor's question of why the council did debate it is that there are some stuff that everybody in that room has thoughts on, which is like negligence, and everybody wants to talk about it. International arbitration, if you're not on the group, I mean, if you really know that stuff, you're going to be on, because anybody, once you're in the LI, you can volunteer to be on as many projects as you want. So that's why I think, like, for example, like copyright, there's some stuff that's kind of, too limited knowledge. Now, my view is, and this is the debate I had, and obviously did not carry today. My partner, Jose Azaraga, was with me as well, but, I respect that we got outvoted. But my thought was, it is a restatement. And on the wall of the room, it says we're here to restate the law, not make the law, but we're not bound by precedent. So there's this big battle in the restatement, which is the most fun part about it is, for example, product liability. The restatement, created that tort, So you are creating law. I felt in this situation, given unanimity of the federal decisions, that restating the law in a way that's contrary to what every circuit had, and I was in fact, we actually had two drafts, if I remember correctly. One draft said we're going to follow the federal way, and then in the comments say this is completely wrong for the reason the professor said. And then the other one was we're going to do it the way we think it ought to be. And then we recognize that we're every federal circuit went day. If I remember, there was competing drafts, and I voted for the draft that said this is what the law is. We're restating it, but we recognize it's not been really explained well, and it probably is wrong. Although I do think, and I'll finish my comments on this, is I think the dissent in this case is probably one of the best well-written explanations as to why incorporating the rules is enough. And I agree with the professor. I remember being in the room reading these cases, trying to make my argument, and finding that all you're getting is that they'll say, yeah, well, 10th Circuit did it, and then the 3rd Circuit did it, and you go back to the first case, and then you're like, okay, well, why'd you get there? And it really wasn't a lot there. I actually think the dissent here did a yeoman's job of trying to explain why it is that incorporation is enough. And had they done that, maybe the restatement might have gone another way.
I do want to expand on something Ed said, and then I'll retire, Giovanni. But as Ed knows, the restaters did something unprecedented in the restatement world. After it had been approved in its entirety, the reporters decided to reconvene the advisors and to revisit 5 positions taken, precisely because they had generated so much controversy, not only during the deliberations, but following the deliberations. This had never been done before, but we thought it was important, in light of the reactions received, that we should do that. So we reconvened the advisors, and we put 5 of the key issues in front of them, one of them being this. Of the 5, we changed our position that had already been adopted on 2 of them. Of course, our change needed to be adopted. That goes without saying. This was one of the 3 where upon revisitation of the entire thing, we maintained the position we had. That's just to underscore what Ed and I are saying, is that this was deeply, vehemently even debated. And I think everybody understood the opposing arguments.
Yeah.
I think that much is clear. I felt like Justice Thomas at times, as the questions were flying, I understood how he feels at the very least. Gio, I see a number of questions from the audience have come in. Do you want to maybe present a few of those?
Quite a few, yes. So get up a little close here because the text is a little small. Justice O'Connor and Allied Bruce reversed her dissent in Southland by saying that after 10 years, enough reliance had been created no longer question Southland. So this kind of goes to, you know, the reliance issue and the majority view that basically we've been operating under for several years now. So why isn't it the same here with this particular issue?
Would you like me to answer that?
Sure.
Okay. Reference was made during the oral argument to the notion of a sliding scale. I think it was Carlos who made a reference to a sliding scale. To my mind, this is a matter for a sliding scale. So reliance is important. It diminishes, its importance is diminished to the extent that the mistake, if there was a mistake, goes sufficiently to fundamental values. And that is my view on the matter. And I'm inclined to agree with Ms. Blanco, as will not surprise you, that I think a very fundamental principle, about as fundamental as it can be in arbitration, is at stake. And therefore, the reliance interest is diminished. I'm not saying it disappears. It's there, but it is diminished. So when the reliance argument is made to me, were I sitting, behind the bench, I would weigh, okay, the seriousness of the mistake that prior courts have made, and that is, frankly, what allowed us to deviate from the position courts had taken. We discussed it with the directors of the ALI. We discussed it with senior members of the ALI, and they agreed that that was the right standard to take. In other words, reliance doesn't carry the day when the flaw is serious enough, because if it's serious enough, it should not be perpetuated. End of story.
Okay, and along similar lines, how important is it, or how much of a factor is it on the issue of uniformity of the law? Should we as arbitration practitioners be concerned that a finding, if the Supreme Court here were to affirm the second DCA, that a lack of uniformity in the law would, whether it's objectively right or objectively wrong, however it is that we want to gauge that, wouldn't the lack of uniformity itself create unintended consequences and create other problems? This is a general open question to anyone.
Somebody else speak. So.
Yeah, I'd like to comment on that, and I think that was kind of a point that William made. I think it is a major problem when you have, in Florida in particular, you've got a scenario or you would have a scenario where you have federal circuits that would be entirely inconsistent with this hypothetical ruling that the Florida Supreme Court would make. And then you would really have not only a race to the courthouse, but a race to find the right courthouse. And so, yes, that's a problem.
I mean, look, the problem with all these arguments is it's a pretty simple solution, right? I mean, just put a sentence in and this is over with. That's the problem. Which is, but that's the ridiculous part of this is that, that's why all this is silly. Are you really going to get a different result if this sentence is in this contract? Are they really going to be able to come in and say, I was unsophisticated, I didn't understand this? This is all silly. The sophistication part, I think, goes nowhere. That's not, that sentence is in and out. I think that you're finding corporations are putting in because of cases like this. Client alerts are going out. By the way, you're in Florida, you better put it in there. Right?
At least if you're in the second, not in the third.
Right. Well, but you don't know what circuit district you're going to be in, right? So, I think what's going to happen, the practical result is that people are going to put in their form contracts, arbitrability goes arbitrary. It's not like I hadn't seen it in other contracts before this case. Usually you argue both anyway.
The CPR has amended its rules to require that the word exclusively be there.
Well, but that doesn't solve the problem. That you're still going to have the same problem there. But that can be helpful. But even with the other arguments we end up making, because I'm a favor of arbitration, like some people, what I usually say is I argue that the language itself, when you read these clauses beyond incorporation of the rules, they always say all disputes, anything, and courts have interpreted the language of any dispute to include arbitrability itself, because it's a pretty broad language. And so the courts have gone beyond just incorporation of rule. And a lot of cases that I've cited talk about just agreeing to any disputes is a delegation of itself.
I mean,
The
one
part
thing that this issue is playing out throughout the country. I know this is something that we've discussed, but there are other cases that are coming up. There was a case that we were discussing the other day with Professor Berman as well that's pending in the Supreme Court, I think, of Texas, Professor Berman. So
Right.
This is a very, very hot topic. I think that that's been illustrated by the discussion and the debate today, but it's also, I think, much more impactful than it may seem. I think on its face, it comes across as a little technical, but in practice, this has a really profound impact depending on which way ultimately the court goes, and to the extent that it would affect probably, tens of thousands of contracts and certainly individual consumer agreements. So this is, I think, and it has been a really interesting and at times provocative discussion, but I think it's at least brought the issues out. And I would encourage those who are here and who are watching today to go back and read the amici, both of Professor Berman and of course of Mias, as well as maybe the parties' briefs. We're only about a month away from the oral argument, so this is going to be playing out in Florida in the very near future, but we can expect reasonably that it will continue to play out throughout the country.
Well, before we wrap up, we promised a hot bench, and then this bench was the bench of 1,000 suns. And I want to give a hand to our able colleagues who handled the questions. I thought they did an outstanding job. It was really great. They handled the questions well, and it was not easy. I'm glad it wasn't me. I was handling me and Professor Berman and the rest of our esteemed panel. So congratulations to the questions.
Yes, well done.
To the colleagues. All right.
Here, here. Thank you so much to Annabelle and Steve for bearing the brunt of those questions and handling them so ably. I believe that concludes our program. I'll just hand it off perhaps to Luis for some final words.
I was trying to Gio just threw me under the bus. I had prepared introductions, but not conclusions. But no, I really thank everyone. I thank the panel. I thank Steve and Annabelle for a tremendous job. And I hope everyone really enjoyed this. This is a hot topic. It's going to be at the Texas Supreme Court. Most courts are unanimous in this, but I think as Professor Berman's amicus brief points out, it's not exactly really been decided. This is something that probably does merit going to the Supreme Court. And again, I think this is the type of stuff that Mias tries to promote. I hope everyone really enjoyed it. Again, I appreciate particularly Professor Berman. The others are conscripts from Mias, but Professor Berman, volunteered. So I thank you, and I thank everyone who listened. And I thought it was great. So thank you so much, everyone.